and welcome back to another episode of Speaking Legally, where the legal meets the cultural. My name is Dr. Stacey N.C. Grant, and welcome to this sixth episode of our show with attorney Royce Russell Esquire and Ed Pichardo Esquire. As I see who's joining in and making sure you all are getting the alerts that we are live, I'm going to let our two co-hosts greet you. So over to you, Ed. You want to welcome everybody in?
Yes, hello everyone. Hello all viewers. I feel honored to be speaking before you today. Once again, my name is Ed Pichardo. I'm a bilingual Dominican American attorney. Hablamos español si necesita ayuda con sus problemas legales. And I feel privileged to be here.
Well, buenos dias. And over to you, Royce Russell.
Just want to say hello and welcome back to another segment of Speaking Legally, and hopefully we can educate those that are viewing. And if you have any questions, just reach out to us. So let's get the show on the road.
Yes, we will do that. Last week, we had quite a bit of feedback on the content that we were covering, a lot of information that we were giving out, and we gave a sneak peek on some of what we will be discussing today. But I know that there was some additional information that both of you wanted to share with the audience around the CCRB complaint process versus internal affairs, and there's like a timeline that we want our community to be aware of when you're filing complaints. So who wants to jump in first on just revisiting some of that?
Well, I'll jump in first, and then Ed, maybe you can follow up on what courts are open during this trying times. I would be remiss if we didn't educate those that are watching and those that are listening about the timelines that need to be adhered to or need to be followed in order to move a case forward when you've been the subject of a false arrest or excessive force. There's usually two avenues that you can go. One is filing a complaint with CCRB here in New York, which is the Civilian Complaint Review Board. Now, noting that there may not be a Civilian Complaint Review Board in your state if you're watching out of the state of New York, if you're watching from New Jersey, you're watching from Atlanta, wherever, but there may be an agency that's equivalent to that you can file a complaint about the misconduct and the abuse of police officers towards you. And then there's internal affairs. I'm not a big fan of internal affairs here in New York because when we look at the name internal and affairs, it never works out to our advantage. And when we say internal, that means that the police department is going to work whatever information they have about your complaint internally, and it's going to be about their affairs and not your affairs to ensure that they are vindicated and that you are vilified and trying to move forward. But those are just two of the avenues that you can proceed. The third is obviously reach out to an attorney like myself or Ed, and then we'll file a notice of claim for you, which in New York has to be filed within 90 days to put the city on notice that you intend to file a claim against this city, against the New York City Police Department for some type of false arrest or excessive force or forced imprisonment, something to deal with misconduct. And then from there, you have a year and 90 days to file your summons and complaint. But we wanted to at least give you that much so you could work on that piece. I'm a friend of always having an attorney on retainer. That means no money down, but having an attorney in your family where you can make a phone call, where you can reach out and they can help you walk the walk. But if not, and you want to do it pro se, which you can, that means by yourself, pro se, representing yourself, you need to know that you have to file that notice of claim that you intend to sue the police department and the city of New York within 90 days. In other states, it might be even less. It might be 10 days, it might be 30 days, or there may not be that requirement, but you need to get to the books in order to perfect a claim if you want to move forward.
I just want to follow up to the best of my understanding too. There are certain requirements for that notice of claim. So if you're going to do it by yourself, without an attorney, make sure you adhere to those requirements and exactly who you have to send it to. Because, you know, the entity that you send it to may not be the right one and you end up missing your 90-day deadline. And it's a pretty hard deadline.
I think that's important, Ed, now that you mention it. So you have to send a copy to the City Corporation Council here in New York. It's 100 Church Street, New York, 10007. And you also have to send it to the Controller's Office, which is downtown, and that is One Financial Center, New York, and I believe their zip code is 10007. But those are the entities that you have to put on notice that you intend to do so. So there are a couple of rules and requirements that you need to adhere to. You can also call 311, which is a civil complaint review board, to make a complaint. You can look at this stuff online, but why recreate the wheel when you have those out there that are trained to do this? And so I applaud you. I ask you to go do that. Seek those that know it so they can represent you and you won't stand alone.
Exactly.
Absolutely. And you have behind you your book, Cardiac Arrest, where that information is also listed so that folks can remember what to do in the complaint process and really be able to have an advantage on giving an attorney like one of you the information that they need in order to get you a favorable result.
And that's
So,
chapter 10 and chapter 11, so you don't have to waste time looking through the whole book.
exactly. Well, now you brought up something else about the courts. And I think, Ed, you were going to start diving into, we're getting notices all across the country about courts opening on different schedules. So depending on where you are in the country, you have to pay attention, but you have some additional news that I think just came out today regarding courts, particularly in the New York City area.
Yeah, well, just to give you kind of some legal background behind all of this, most people are aware that the Governor Andrew Cuomo, issued an executive order regarding the COVID-19 crisis, setting certain rules, protocols, suspending certain laws. People have heard about the suspension of eviction proceedings and so forth, the closure of courthouses. And so the chief administrative judge followed that up with an administrative order in March. And from March till, even today, there have been slight amendments and changes and additions to that administrative order. About maybe a week and a half ago, electronic filings on some non-essential matters that were actually pending was allowed. So then, attorneys were able to file some of their documents with respect to that electronically. Today, in fact, a memorandum came down from Judge Lawrence Marks talking about the filing of new non-essential matters, which is big because now, a lot of attorneys have been holding off on filing, new lawsuits and so forth because they just simply, were not allowed to. And so with this new memorandum, apparently it paves the way for that as long as the represented parties consent to electronic filing, meaning that they consent to receiving the pleadings and the papers electronically. And, we can go on about, well, how does that take place? As an attorney, you have to have this electronic court filing account that you initiate based on, you having a bar license and able to receive and send pleadings. But, just want to give you a heads up on that. It's a May 20th memo. Today is May 20th, so it just came out today. There was an administrative order that came out on May 18th that added surrogates court to a list of matters that could be filed. And in particular for surrogates court, it's any matter involving an individual who passed away due to COVID-related causes. And so, in plain English, if you have someone who passed away, either with a will or without a will, now, you're able to have those matters filed with respect to that individual now. So that was something. And just to circle back a little bit, there were a list of courts or certain matters, because courts and matters are a little different. Like, for instance, for criminal matters, criminal courts during this COVID crisis, what was allowed to transpire, allowed to take place were arraignments, bail applications, reviews and writs, temporary orders of protection, resentencing of retained or incarcerated defendants, and essential sex offender registration act matters. So those were matters that were considered matters that could not be suspended. You know, somebody getting charged and the prosecutors having to have that person arraigned, and, you know, seeing a judge, bail applications. And when I say seeing judge, in a previous issue, you know, Royce talked about the experience of having to be behind a barrier, speaking to the client by way of video. So, you know, don't take me literally. And also with all of this, you know, don't, you know, go running and say, oh, Ed said this. All of this is in writing. So, you know, I would warn you to, you know, both practitioners and non-practitioners, to look at these documents yourselves and come to your own conclusions as to whether it's time to file your matters or not. But just to kind of give you that little tidbit, these were criminal matters that were allowed to take place while others were not. They were, in fact, I had a case that was postponed. You know, no hearing took place, but there was no one, you know, the client wasn't incarcerated or otherwise detained. So, you know, that matter was adjourned. Then you got family court. So child protection intake cases, that was still being done. Newly filed juvenile delinquency intake cases, placement applications, emergency family offense petitions, and temporary orders of protection, orders to show cause, stipulations on submission. And then with respect to the civil Supreme Court, mental health issues, mental health law applications and hearings addressing patient retention and or release, involuntary administration of medication, those sorts of things. Election law applications, it's still election season. Temporary orders of protection, once again, including but not limited to matters involving domestic violence, extreme risk protection orders. And then with the housing, civil matters, eviction proceedings halted, but you could still file applications addressing landlord lockouts. Like when your landlord says, nah, you can't come in, you ain't been paying your rent. You know, you still could get a court for that, including reductions in essential services, applications addressing serious code violations. The water's gushing in your apartment. You can't go to court for that. You know, you don't have to just stop. Addressing serious repair orders, you know, applications for post-eviction relief. You got evicted right before. You want to file papers, something went wrong with that. That was something that didn't stop. That was listed as an essential matter that could proceed. And then all courts, any other matter that the court deems essential. So if you had something that fell out of one of these boxes, but you could still make the case that it was an emergency and that you needed it addressed by a judge or the court, you know, you could still make it, and then it would be up to that judge to decide whether or not your matter was essential or not. And, you know, and as lawyers, you know, we have to make sure we don't file anything frivolous, right, Royce? So
that's right.
So
as I listen to you go through the, you know, I must say it is very complex. It's not anything that someone can just immediately gravitate to and know exactly what to do. So with that being said, we're just going to give you a little bit of a cheat sheet that you can handle. One is that anything that has to do with you being kicked out of your home in the time of this pandemic, that is considered essential, so you can go to court. Whether it is water leaking from the roof, whether it is you didn't pay your rent, whether it is your garage opener's not opening, the landlord changed the locks on the door, that has to do with you being out in the public rather than sheltering at home, you can go to court. If it deals with order of protections, per se, someone's in danger, whether it's family or otherwise, and it has to deal with you being ousted out of your place of living, that is essential. Anything that's criminal, where you have a lawyer which is representing you, whether it is legal aid, whether it is a public defender, or whether it's a private attorney, you should not have to worry about it, because that's why you have representation. You have an attorney there. So I want you to take that off your plate, because you are 9 times out of 10 not representing yourself. Now, when it comes down to matters such as what we talk about most of the time, is filing civil suits or filing lawsuits against the police department. This is where it gets critical, because you may have had a timeline for which you could file a lawsuit, and that timeline was suspended. Now what we are telling you is that that timeline has been reactivated. The courts have said they're open for business starting May 25th, right after Memorial Day. So you can't wait another 3 months and try to rely on COVID as a reason why you didn't file your lawsuit, because as of May 25th, the doors are open, not the literal doors, but the virtual doors are open. And so therefore, you can now file your claim electronically. Ed has mentioned that the other side has to consent. Well, I'm here to tell you, if you're representing yourself, you need to file anyway, because at least you're showing good faith effort that you want your case heard before a judge. Because if you wait for the other side and the other side knows that you are representing yourself, they are going to drag you through the mud. So these are just tips that we're giving you. We know that we don't have an attorney-client relationship, right, Ed? So we throw that disclaimer out there, but we are just giving you tips so you can understand how to protect yourself and preserve your rights. And if you have an attorney and you think that that attorney is snoozing, and as they say, if you snooze, you lose, because the case is about you, don't lose. Call the attorney and say, I heard on Speaking Legally that this is what's happening. And maybe, you don't know, you can save yourself the heartache of trying to prove why you didn't file your case because you thought the courts were still closed. So I know that's a handful and a mouthful.
I was just about to say that's a handful and a mouthful. So let's digest it a little bit more, because I want the audience to make sure you take away the fact that particularly in New York City, the courts are opening May 25th, correct?
Virtually.
So, virtually. So for certain things that they have deemed essential versus non-essential can be still handled and filed.
Well, it says beginning that day, e-filing through New York State CEF system, including the filing of new non-essential matters, will be restored in those counties of the state that have not yet met the benchmarks required to participate in the governor's regional reopening.
Time.
That's a lot. Can we get it for the layman?
Time out. So, and I know you meant to do this on purpose to show everyone how exaggerated it is. If you have a new lawsuit, simply you can file it as of May 25th electronically. If you don't have access to an electronic system, that is a whole nother barrier. But if you have an attorney and you think your attorney is snoozing, you need to let the attorney know that as of May 25th, everything is up for grabs. You can file. Don't worry about essential or non-essential. File.
And I'm going to back up Royce on that, because there's even a sentence here in parentheses that says, unrepresented litigants may continue to file, serve, and be served papers through non-electronic means in those cases. So that means don't take any chances. Do what you got to do.
Now, I need you to say that for our Latin family. You need to let them know that the courts are open.
Well, le quiero dejar saber a la comunidad latina, hispana, que la corte ahora van a abrir, empezando el 25 de mayo. Ellos van a recibir papeles electrónicamente, pero también están diciendo que cierta gente que están representándose ellos mismos en ciertos asuntos pueden continuar metiendo papeles en las cortes, sirviendo esos papeles y recibiendo papeles a través de métodos que no son electrónicos en estos casos. So, ahora mismo le estoy advirtiendo a la comunidad que si usted tiene algo pendiente, debe contactar a su abogado si tiene un abogado para preguntarle el estatus de su caso, o si uno está planeando meter su caso propio en corte, pues ahora es el tiempo de empezar haciendo eso y empezar ese proceso. Okay.
Gracias. So we want to make sure that our community understands, because we don't know what's coming and what's next and what you already have on the table. If you can get a private attorney, you have two right here that can advise you and work through the process with you. But definitely we want you to be informed about the changes. Things are happening really fast in this new normal that we're living in. So the legal meeting the cultural is important so that you really understand the information and share this broadcast with those that you think need to hear it. Everybody has situations going on, and there's no need to suffer in silence. You have two experts here that can guide you and give you just some insight. There's no attorney relationship that you have right now because you haven't retained them as your attorneys, but you have the benefit of their knowledge on this show, being able to help you navigate these new waters and be mindful of the things that you need to know about. So with that being said, we're going to switch gears into something that Mr. Russell touched on last week. And given this COVID-19 climate that we're living in, everyone's sheltered in, there are limited choices on what you can do and where you can go and how you proceed. And it's raised a huge red flag for situations of domestic violence. We know that this is something in our community that we've had a lot of advocacy around, being able to give resources and bring information to help save people's lives. Of course, the majority that we see, it's the woman, but there are men in the situation as well. And domestic violence is an issue that we have to deal with. But in this COVID-19 climate, I really want us to go into what Mr. Russell raised. How do you manage if you are in a dangerous situation? What should you do? How should you do it? What kind of information can we give? Because we see what the numbers are saying, and we don't want anyone to lose their life unnecessarily. Definitely not to the virus, but not to domestic violence.
Well, when it comes down to life and death, I don't think you can wait, right? And so if you are victimized or you're a victim of abuse, whether it is physical or otherwise, because the mayor or the governor has curfew or rules that you cannot leave your house, I say to hell with that. You know, mask or no mask, any type of sanitizer you have in your hand or no sanitizer in your hand, you need to file a complaint with the police. You need to make sure that your voice is heard. You need to pick up the phone and call the police. I know we have our fears, and I know rightfully so, we should, as to how police interact with our community. But if you're in danger, you need to seek help. So I put down all of the requirements, COVID, all the other limitations that are there, and make sure that you go about seeking help. And what supports me in that is that, as Ed has said, when he read through the essential filings, things for which the court is open, when you look at family court are open to those matters. They're not going to turn you away. So you need to knock on that door, whether it's virtually or whether it's physically, and get in. Now, we could talk about on the flip side, which we will. I'll allow Ed to give his thoughts on it, but we will talk about on the flip side on what to expect when police do come knocking on the door. But you need to file, and file quickly.
Thank you, Royce. Ed?
Oh, well, Royce is absolutely right. On the flip side, in many cases, we will represent individuals who are actually charged with the crime itself of domestic violence. And, keep in mind that if the police show up, that more than likely, if there's some proof of some sort of assault, physical violence, or threat of violence, in many cases, the accused is going to have to leave that home. Now, whether or not they get a desk appearance sticker or ultimately detained is going to depend on the facts of the situation. Now, in many cases, what ends up happening in these cases is that it happens between people who know each other. So what ends up happening is the person who's charged will say, well, I heard, because they're not supposed to have contact with each other, I heard that he or she was dropping the charges. And so why am I still going to court? Why do I still have these charges pending? And they don't understand that it's not like a civil matter where you have Jane Doe versus John Doe. That's not what happens in criminal proceedings. If you notice, if you look at the caption of any criminal case, you will see the people of the state of New York or the state of New York versus John Doe. And the reason being that it is the county in which you live, the district attorney's office in that county, that has jurisdiction over the bringing of prosecution of criminal actions, of criminal prosecutions. It is the district attorney's office, the elected, if you will, lawyer for the people of that county that is the chief law enforcement officer who is empowered to bring those cases. So even if your girlfriend, in the case of, say, a woman has made the initial police report, or, you know, a man or spouse or whatever, it's not that person that controls necessarily whether that case gets prosecuted against you or not. It is the district attorney that is prosecuting that case, and it is the district attorney who will need to make a motion to dismiss that case unless you take the case to its conclusion and a judge ultimately drops the case. And then we could maybe also talk about the conversion of a criminal information and so forth, which is a document that has to be filed by the district attorney that has to be signed off by the victim saying, well, I'm sorry.
I was gonna say, let's pause right there, because before you give that detail, let's circle back, right, to the fact that if there's a domestic situation and the cops are called, regardless of whether or not you make up afterwards or you feel forced, pressured, whatever, to take back what you said, it's too late. Once they've been called, if I'm hearing you correctly, and charges have been filed, it's now in the hands of law enforcement and the attorney presenting the case or the DA that's prosecuting the case. You can't undo what has been started.
Well, the police, I'll let Royce cover that one.
One of the things that we need to really recognize is this. If a call is made and the police come, first point of contact, this is the difference between knowing the law and knowing the law. If you know the law, you know that somebody's gonna have to leave that apartment, that residence. If you think you know the law, then you might be beating your chest saying that you can't arrest me and you can't force me to leave my own apartment, especially during the time of the pandemic. So, answer, you will be forced to leave because the police are not going to take a chance on allowing anyone to stay there, and further harm is caused by the victim, whether it's death, whether it's hospitalization, because then they're leaving themselves liable to a lawsuit, and they've already been sued left and right. So you will have to leave. That is one. And what I've been preaching, and what Ed has been preaching, and what I've talked about through cardiac arrest, is that you need to understand police are people too. So when that police officer rings your doorbell and knocks on your door, you have to take in consideration whatever background and baggage that person may have in their personal goodie bag that may cause them to act a certain way towards you. They could be going through a divorce. They could be a victim of child abuse. They could watch their family have gone through a divorce, or their sister or a loved one. So now they're at a domestic violence call, and so they may not treat you so kindly. So you need to pack up and get out. That's one. Two, as Ed was saying, when it comes down to order of protections, let's just say we broad brush and just now we at a point where there is an order of protection, because I think this is important. And we'll have other guests come on speaking legally, and we can go through dotting the I's and crossing the T's. But if you have an order of protection that is filed against you, as Ed said, it is not up to the person, the woman or the male for which you have an order of protection against, or where you can't speak to that person. It is not up to them to determine that if they text you, you can text me back. If they Zoom you, you can Zoom me back. If they Instagram you, you can Instagram back, or TikTok, or Talk the Tick, or whatever it is, whatever mode of communication you think that you're going to use, because boo and bae is all right now. I'm telling you, you can't do it, because it is an order of protection, which is a contract between you and the judge, a contract between you and the judge. And that is what matters, not anything else. So save the texts, save the boos, save the I love yous, save whatever it is that they sent you, put it in your back pocket. They understand that you cannot be in contact with them. And if you violate that, you're setting yourself up for a downfall.
You're not only setting yourself up for possible brand new separate charges, but you can also be found to have violated the conditions of your release and possibly, cause yourself to, be detained for the remainder of your case because you violated, as Royce stated, your agreement with the judge.
And that's an easy 60 days in jail. It's called contempt of
Wow.
court. It's a B misdemeanor. So stay away from it as far as you can. And we know that it's trying times. That's why we're bringing it up. We know that there's an uptick in domestic violence. We know there's an uptick in not necessarily obeying the rules and the laws, because there's other things that police officers should be involved in. But we know that the heavy hand of the law on the community of color has not been lifted. So your doorbell will ring, the knock will come, and you will be processed and prosecuted, because they have not stopped policing our community, and they're not going to stop over policing our community. And in this particular case, I would say that it's better to be safe than sorry anybody who might be victimized.
And and for individuals who are experiencing a certain level of stress, if your mental health is an issue, I know in our community, many men of color have a problem seeking help. Please seek help. Call 311, ask for the mental health line, ask to speak to a professional, ask to speak to somebody to talk about the stress. Maybe you're on furlough, or you've been laid off, or you can't earn right now, and you're not making any money, and you're stressed out. You don't know what's going to happen next, and then sometimes that causes you to take it out on the person that you love, and or the children around you, or whoever it is that lives with you. And you have to think. You got to think and put the thinking cap on and say, it's better for me to seek some help, talk to somebody, than not, and then have this thing turn into a situation that completely spirals out of control. So please, I implore members of our community, por favor, le digo a todos los miembros de la comunidad, si usted está teniendo un problema con su salud mental, si está sufriendo de estrés y necesita hablar con un profesional, llame el 311 y alguien va a hablar con usted y ofrecerte esa ayuda.
That is so important and key to really share this message, from both ends. It's a sad hurt people, and we'll never condone anyone getting hurt. And we really want to make sure that with the uptick in domestic violence, that nobody's suffering alone, that they realize that they do have some sort of recourse. And as Royce said earlier, you want to save your life. So whatever that means and whatever you need to do to get to safety, to get order protection, we're just explaining all the way through what happens once that is in place. Because unfortunately, there are also instances where people or individuals have the cops called on them unfairly, right? And that we find out later on through a case in a trial that it was a wrongful charge or situation. So there's so many different layers and angles to it, but definitely we want you to make sure that you do not put yourself in a situation that you don't have to be in by staying, that there are hotlines, as Ed just shared, that you can call and you can get help. You can call 311. There's all sorts of health and mental health opportunities for people to log on and get support and resources. So at the end of the day, we have to take care of ourselves in our community. And if we see something that doesn't sound right or look right with someone that we love or care about, let's not sit silently on the sidelines until something tragic happens and we say, I wish I would have. Let's be ahead of what could possibly happen and not reactive, but proactive.
One of the things I also want to add is that, and Ed, you touched on it, that people believe that if the complaining witness decides that they do not want to go forward, that the case will go away. And that's not the case, because we've seen cases being prosecuted where the victim does not want to go forward. And sometimes the district attorney's office is able to still proceed with the criminal charges. And we say, how can that happen? The slick guy in the community or the slick abuser or oppressor in the community saying, look, that person does not want to go forward. And I don't want to be biased to any particular agenda, but that person does not want to go forward. And so therefore, this case will be dismissed. Well, sadly, but not so sadly, the court and the law has arranged it that if there is a 911 call where the victim is calling the hospital and is saying, my girlfriend or my boyfriend is beating and hitting me right now, well, that call can take the place of the victim being present. You know, we will not go too far into an excited utterance, but that's what it is. It is a contemporaneous statement that's being made at the time that the situation is occurring. So they can use that 911 call, and when I say they, the prosecutor can use that 911 call to establish that that complaining witness was being beaten or harmed or abused at that time, and then use circumstances to establish that you were the person that was in the apartment, and it was only you two, or maybe it was you and some kids, and when they arrived you were present, and therefore they made the arrest. So sometimes these cases can be tried and prosecuted what we call, which we have now become very used to, virtually, you know, without the person being present, because we have a live recording. And I say that because I don't want our community to be misinformed and misled in any shape, form, or fashion, whether I, as a former prosecutor or now as a defense counsel. The truth is the truth, and trying to be a truth teller, I want our community to know what could happen to it.
Yeah, absolutely, because what you're dealing with here is certain situations where the police officer can testify independent of a victim. Like, for instance, if that officer gets to the scene and observes actual injuries on the victim, that's something that they can testify to on the stand. My name is Officer Pichardo. When I arrived at the residence, the complaining victim had a swollen eye, bruises, blood on their shirt. They can testify to that. They don't need her up there on the stand saying, yeah, this happened to me. It's going to ultimately be up to the jury, of course, or if it's a bench trial, under some circumstances, maybe, depending on the elements and what the charges are. But at the end of the day, that officer is allowed to testify regardless of that victim being present or not. Same thing with that 911 call and any other evidence that they don't specifically need the victim for in terms of meeting their burden. So, this idea, in the community that, oh, well, she wanted the charges dropped, he wanted the charges dropped, why is this continuing? Sometimes we get instances where victims will contact us and say, well, what do? I don't want the case to go forward. I already told the police. I went to the station and told them I want the charges dropped. The district attorney called me the other day and they want me to come in and sign some paper. And, I don't want this thing to continue.
Do they say it in that type of voice, though, Ed? Do they use that?
I'm sorry. Yeah, that's probably improper, and you're absolutely right. I'm kind of just voicing the angst and concern that some of these folks have when they contact me, man or woman, as to what's happening, because it happens as Stacey mentioned earlier, as the doctor mentioned earlier, on both sides, both genders. I tried, I had a client one time who, my client, the defendant, was a woman. She was accused of beating up her boyfriend. She was former military, and, not that to say that means anything, but, I've encountered cases where, both were the same sex. It doesn't really matter, so I didn't mean to convey that they speak only a certain way, that it's only
No, I know you didn't. I know you didn't. One of the things to add on to what you were saying is that basically what I hear in your voice is the person now having empathy and sympathy and want this whole thing to go away, and it can't go away. And then, if you want to add the cherry onto the top of the ice cream, just imagine if there was an order of protection that was involved, and that other person is saying, well, she texted me to come on over, or he texted me to come on over, or whatever the situation may be. So now you have a contempt of court on top of the domestic violence situation. And if we're really going to be truth tellers, we know sometimes this is a catch-22, that sometimes this is done intentionally, where one person is called over knowing that there's going to be a violation of an order of protection, and everything's good until everything is not good. And now you got a violation of order of protection, and now you got a potential domestic violence situation, even though it wasn't anything physical going on. It might have been verbal, but you wasn't supposed to be there in the first place.
And let me talk about a cultural aspect to this thing as well, because, you know, we both, you know, live in a community, have lived in a community. These domestic violence situations get extremely complicated. If in many cases, the person being charged and having to leave that home is a breadwinner. The
Oh,
person
yeah.
who pays the rent, the person who pays the bills. The criminal justice system is completely, they're not adequate when it comes to dealing with these situations. There seems to be this severe preoccupation with prosecution and very little support for, you know, these victims. So when that sister's saying, or that brother's saying, hey, listen, you know, I can't have this continue. Sometimes it's simply, look, he was paid. Yes, it's strictly economics. It's child care. It's, you know, kids are like, where's my mom? Where's my dad? You know, what's going on here? There's a lot of stuff going on. It gets extremely complicated, you know. So I just wanted to kind of add that dimension to it as well.
Well, we're not blind to the cultural aspects, although Lady Justice might be blind as they hold the scales up there. But we understand that, you know, breaking up the family unit has been going on since slavery, and and it continues. And I know we might digress from the domestic violence that we're talking about, but you know, this is history. This is our culture. This is bringing culture. This is bringing legal. Is bringing both of those things together, and having that understanding, and having that empathy, and having that wherewithal, I think makes people better advocates for those that are in those positions. I mean, we've always talked about, you know, what does the face of change look like? You know, whether it's in civil rights and protecting those that are subject to abuse and excessive force, to being a defense counsel, defending someone if they happen to be a person of color that is facing the death penalty or facing something as small as a trespass because they stand in front of their building, or something as a domestic violence. Understanding all those dynamics always bring me back to, if we stay within the color diaspora, we will get more bang and more mileage and feel more satisfied as far as our representation and what we got out of the criminal justice system, the system in general, and how we thought our case was managed. And I will always preach that, bring that up.
Absolutely.
And I also want to mention that I want to put on my labor attorney hat for a hot second. Keep in mind that there is a law in particular in New York City that if you're a victim of domestic violence and you're having to miss work, you know, and I believe this is for a city job or a job, you know, such as, say, you work for transit or the city, you and let's say you get you end up getting disciplined for missing work or otherwise, you know, it affecting your duties, that one of the defenses to those disciplinary proceedings is having to attend court hearings and or missing work because of this domestic violence case. So if you're a city worker, municipal employee, or transit worker, and you're also the victim of domestic violence and you're missing work because of those cases, make sure you keep those records. So if your employer files disciplinary charges for absenteeism or the like, you're able to provide that to, most of the time you're going to get a lawyer from the union representing you. Make sure you have that ready to say, hey, listen, this is what's going on. And I know it's hard sometimes for victims to talk about this because sometimes they're a little ashamed and they don't want to talk about it, but it's better for you to be candid with your attorney. And you know, when I was a union lawyer, you know, I would pull the labor relations attorney to the side and, hey, look, I don't want to make a big deal about this. My client is, you know, concerned about this getting out to the other co-workers and so forth. But, you know, this is what's going on here. Let's drop these disciplinary charges and let's, you know, give her a chance to deal with this. And most of the time it worked, but I just want to point that out.
I think that's important to really consider all of that. I know you were saying something, Royce. I'm going to let you jump in. But as we're winding down, I mean, this was a full show and on a very serious topic. Of course, I hope everyone took notes earlier on when we opened up about how to file for a complaint, when to file, what the deadlines are, so that you are equipped with the right knowledge, because courts are opening up. But when it comes to domestic violence, we could be on multiple shows just talking about the different layers and the effect that it has, particularly in our community. But we want to drive home the point. Please do not suffer in silence. There is help available. Reach out to get that help. Don't feel embarrassed or ashamed. It's not your fault, and you did nothing wrong. We want you to be able to survive, and we want you to be able to protect yourself. So there are resources available from 311 down to a multitude of websites that you can go to if you just Google support for domestic violence, particularly here in New York City, but all across the country. Thank God for the advocates. Thank God for those on the front line that are really doing their best to help decrease those instances of domestic violence that are appearing in our communities, particularly, and even more so now because of COVID-19. Royce, I'll let you go ahead and finish your final thoughts, and over to you, Ed, before we wrap up today's show.
Well, just elaborating on Ed's comment as far as protecting yourself at work when you have to deal with domestic violence. As we forward think, and as we are labeled forward thinking people, we should start to contemplate how we can use that when it comes down to your civil rights being violated. If you're being abused by the police and you have a lawsuit against them, or if you've been a victim of excessive force and you have to miss days of work in order to pursue that, I think that there should be some leverage to make sure that you're not disciplined again because you're missing days of work to pursue something that was not your fault, that you had no hand in, but for the fact that you were of color in America. So, you know, are there people out there that are advocating, that belong to unions, that belong to various other civic groups? Maybe they can take on that task to ensure that that is a defense and that is a protection that those who work for the state and work for the city can also have as they try to seek some type of redress in pursuing justice.
Awesome. Thank you, Royce. And over to you, Ed. And let's also wrap up some of the summary of this conversation en español por la familia.
Quería comunicar a la comunidad latina que si uno está trabajando en un trabajo de la ciudad o un trabajo gubernamental y está sufriendo o fue la víctima de violencia doméstica, y su empleador quiere disciplinarlo por falta de trabajo, por uno teniendo que atender ciertas audiencias de corte, eso es una defensa contra esa disciplina. So tenga eso en mente si eso es lo que le está pasando a usted. And just to wrap up, you know, I echo all of Royce's sentiments here. You know, and you know, with respect to, you know, labor organizations looking at the issue of their members having to miss work to attend court because they were the victim of some sort of police brutality incident, that's certainly something that should be looked at, lobbied for, not only when you're doing contract negotiations to get it into possibly the collective bargaining agreement, but also get it into law, both on the city and state level. So I think, you know, that's definitely something that should be looked at if it's not already there to begin with in some form.
Awesome. Great content today. Once again, attorney Ed Pichardo, Esquire, and Royce Russell, Esquire. Let everybody know your contact information. If this is the first episode that they're catching of Speaking Legally, you can directly contact these two attorneys to give you additional guidance and enter in to having a relationship, client-attorney privilege relationship with either one of them. So Ed, you want to go ahead and tell them how to contact you?
Well, once again, Ed Pichardo, Esquire. I can be contacted at 718-514-9099. Eso es 718-514-9099. Okay.
Gracias, my friend. And over to you, Royce Russell, Esquire. How can they contact you?
You can reach me at 718-785-8890. That's 718-785-8890. You can follow me at www.roycerussell.esquire.com. You can also follow the book Cardiac Arrest, and you can email us at cardiacarrestbooklaunch.net. Keep in touch. You can always find us by way of Facebook. You can find us by way of the internet. It should never be said that you can't find us because we're here to be found. Take care and be well.
Thank you so much. And that's www.cardiacarrestbook.net. And you can email at cardiacarrestbooklaunch@gmail. So thank you so much for tuning in to another episode of Speaking Legally. This is Dr. Stacy signing off. And we look forward to seeing you same time, same place next Wednesday, 4 p.m. Eastern Standard Time. Bye-bye, everyone.
All right.